Session number 12 of the military law series pertains to separation from service. That means how does the service in military comes to an end, and the aspects relating to disability benefits. There are certain essential components of this session. These impact on tenure of service, for how long and till when would the service tenure last. Then how does the service come to an end, or the separation from service, the aspects pertaining to dismissal, removal or reduction. There is a difference between the terms dismissal or removal. They have a very specific connotation. Insofar as persons below officer rank as well as the officers, there are three terms: retirement, release or discharge. Discharge is not applicable to officers. Then when a soldier gets out of the army, a certificate is given to him on the termination of his service or the service coming to an end. What happens if a soldier is part of a contingent which is positioned outside India when his termination becomes due? And lastly, the aspects relating to disability benefits, what they are. The law in this regard pertaining to separation from service and disability benefits is contained and stems out of Army Act sections 18 to 24 and the rules 11 to 18, which would be relevant for the purpose of this session. It is to be appreciated that tenure of service under the Act, as laid down in section 18, is at the pleasure of the President. The section reads out that every person subject to the Act. Now, this takes within its ambit all ranks, whether they are officers, junior commissioned officers, warrant officers, non-commissioned officers, or other ranks. They are all included in every person subject to the Act, shall hold office during the pleasure of the President. Now, this is something very significant, and we would cover this in little greater detail. It is parallel to or based on the philosophy, the law contained in Article 310, that every person who is a member of the Defence Service holds office during the pleasure of the President. So this is known as Presidential Pleasure Doctrine, or in short, Doctrine of Pleasure, that it is the President who is pleased to give a job, to take somebody in service of the armed forces, and he can have equal pleasure in taking the pleasure back, which means or which brings about separation from the service. The important point to note here is that no ground or opportunity or an stage or opportunity to show cause is needed to withdraw the pleasure. Now, there is a settled case law on this, that presidential pleasure doctrine, if it is being invoked, then it is not necessary that any show cause notice is to be given. Now, this has to be viewed from the point of necessity. Supposing with a particular country who is across India's border, the relations improve, there are treaties bringing about signifying peace between the two sides, and the government decides to disband one corps. Now, as many persons or who are officers or persons below officer rank may not be needed anymore, and therefore President can simply say that all the troops forming part of, say, Northern Command or Eastern Command, they are the presidential, under the presidential pleasure doctrine, they are no longer required, or their services are no longer required, and their service would come to an end. So therefore, there can be different contingencies when this pleasure is required to be invoked. There is no stigma attached to it, and it is the pleasure doctrine. Pleasure is taken back, and the person is out from the service. It is also to be read in context of Article 77, Clause 1 of the Constitution of India, which pertains to conduct of business of the Government of India, whereby Clause 1 states that all executive action of the Government of India shall be expressed to be taken in the name of the President. Now, what does it entail? It explains that the action which the union government is taking, it would be spelled out and exhibited as if it is in the name of the president. President personally may not be aware. It is not necessary that each such document should be seen by him or should carry his approval. By virtue of Article 77, Clause 1, all such actions are to be taken constitutionally in the name of the President of India. For the exercise of presidential pleasure doctrine, there is a case law in the case of Wing Commander Hazara Singh versus Union of India, where it was held by Delhi High Court that no restraint order under the Act or rules can be put on the presidential pleasure to determine the services of a member of defense services. Therefore, it meant that where the presidential pleasure is being invoked, there can be no restraint order under the provisions of any statutory law, rules, etc. No opportunity of hearing is necessary before passing the order of dismissal. Therefore, this order of presidential pleasure is not open to scrutiny, judicial scrutiny. Then this rule indicated in Hazara Singh's case was slightly amended and explained by a subsequent decision of the Supreme Court, wherein it was brought out that it is not open to judicial scrutiny except when some mala fide is being attached to the exercise of presidential pleasure, and if that is being done, then onus of satisfactorily proving to the court, indicating to the court that there is a mala fide would be on the petitioner, and in case he satisfactorily discharges this burden, then the order can be looked into, or the veil can be lifted, and the desirability of that presidential pleasure action gone into. Therefore, as the law exists, dismissal can be exercised in the name of the president, which is being done when anybody's services are to be brought to an end. Then the order says an order is issued in the name of the President of India, and mind you, Articles 310 and 311 are not applicable to defense services, and therefore suitable provisions have been inserted in the military law, that is the Army Act, Navy Act, or Air Force Act, under which the presidential pleasure doctrine can be suitably invoked. Apart from presidential pleasure doctrine, authority is available to the central government under Section 19 of the Army Act, where termination of service can be ordered by the central government, and the Act, the particular section reads that subject to the provisions of the Act and the rules and regulations made thereunder, the central government may dismiss or remove from service any person subject to this act. Now, I'd like to highlight here, if and when the central government has to take recourse to Section 19, then it would be subject to the provisions of the Act. Mind you, whatever is there in the Act, and by the Act it means Army Act, those provisions would need to be satisfied, and in case if there are corresponding rules in the Army rule or in the regulations for the Army, they would also need to be duly adhered to, and therefore exercise of the clause under Section 19 would take place in accordance with the provisions of the Act, Army rules and the regulations, and then the government can remove, dismiss or remove from service. There is a difference between dismissal or remove from service. We will see this shortly. Any person, which includes even the officers, can be removed from the service. Next, we saw Section 18 that pertained to the presidential pleasure. 19 was authority with the central government, and next is Section 20. 20 talks about the authority of the Chief of Army Staff, and it says dismissal, removal or reduction. So there are three actions that can be taken: dismissal, secondly removal, or thirdly reduction in rank by the Chief of Army Staff and by other officers under Section 20. Now the Section 20 clause 1, it has 5 clauses, says the Chief of Army Staff may dismiss or remove from service any person other than an officer. Therefore, officers which carry the rank from lieutenant to Chief of Army Staff, they cannot be touched, they cannot be proceeded against, and persons other than officers, their services can be brought to an end by way of dismissal or removal by the Chief of Army Staff. Further, under Clause 2, the Chief of Army Staff may reduce to a lower grade or rank or the ranks any warrant officer or non-commissioned officer. Now, supposing there is a Havaldar. Now, Havaldar can be brought down if he is being brought down by rank, so he can become a Nayak, or he can be made a Sipahi, then he is brought down to the ranks. And similarly, a person who is in grade 3 may be brought down to a lower grade. This is only applicable in case of persons who have different grades. So the reduction, in other words, can be by way of rank, in the rank, or to a grade. Now this can be done by a person holding the post of Chief of Army Staff or other officer. Then clause 3 says an officer having power not less than a brigade or equivalent commander. Firstly, it is a commander. There is a difference between commander and staff officer, so these powers are not available to staff officer. So a brigadier who is a commander or any prescribed officer, and it is upwards, not lower than the brigadier, may dismiss or remove from service any person serving under his command other than an officer or a JSU. Point to be seen here is that the lowest person who can exercise authority under clause 3 is a brigade commander. He has to be a commander. Number 2, the action that he can take is either dismissal or removal, and this he can do with regard to an officer or junior commissioned officer. So you would have seen that a junior commissioned officer can be removed by the Chief of Army Staff, but a brigadier can only proceed against a person other than an officer or junior commissioned officer. That means with regard to a person who's not an officer or a JCO, who doesn't belong to these two categories, the brigade or equivalent commander can proceed. Now, clause 4, Any such officer, which I just indicated, that means brigade or equivalent commander, may reduce to a lower grade or rank or the ranks any warrant officer or any NCO under his command. Now, where dismissal from service is not intended, that would perhaps be more serious, then inferior or lesser injury can be inflicted, if I use the word injury, by way of removal or reduction to a lower grade or rank or the ranks. I would again give that example that say a Havaldar can be, when he is being reduced to the ranks, he will become a Sepoy, and if he is being reduced only in rank, then he may be brought down to the rank of Nayak. Clause 1 gives a caution that a warrant officer who is reduced to the ranks shall not be required to serve in the ranks as a sepoy. Now, a person who has reached the rank of a warrant officer, if he is to be proceeded, then he would separate from the army. He will not serve in the same army where he had risen to the rank of a warrant officer in the ranks. Then he needs to go out. The next two clauses of section 20 say that commanding officer of an acting NCO may order him to revert to his permanent grade or as an NCO, or if he has no permanent grade above the ranks, to the rank. Now, we had seen in the earlier clauses the authority vested in the Chief of Army Staff, persons below brigade or equivalent commander, and now here we come to the commanding officer. What power is available to him is indicated in clause 6, where he can proceed against an NCO, acting NCO, who can be brought to his permanent grade as an NCO, or if he has no permanent grade, above the ranks, to the ranks. And clause 7 says the exercise of any power under this section shall be subject to the set provisions contained in the Acts, rules and regulations. And therefore, what clause 7 indicates is that the rules and the regulations which have been made concerning this power shall be duly adhered to when action is being taken under Army Act Section 20, Clause 7. Therefore, these are very significant sections which are available to be invoked as and when required under the Army Act provisions. I had indicated two terms, dismissal or removal. Now, dismissal can be by two ways. Dismissal can be ordered as a punishment by way of a court martial, and it can also be an administrative action. Now, this means that when a person is dismissed, he goes out from the service, and it is a bar to further government service. He cannot hold any or cannot apply for any other government service job. He is not entitled to. A removal is lesser in gravity. It brings about the termination of service, but then coming back into service or further government employment is not a bar. Then that indicates the difference between dismissal or removal. Removal, a person who has been removed can be applied, can be given a separate further job, which is not in the case of dismissal. And therefore, the main difference is that there is no disqualification for reemployment in the case of removal. Now, the next term was discharge. Discharge is not applicable to officers. It is an administrative measure which brings service to an end. It is not a punishment. It is an administrative action that is permitted under Army Rule 11 Clause 2 and under Army Rule 13, where a person can be discharged. And the word retirement carries the stipulation which means that a person is withdrawn from service, and it is generally by way of superannuation. So it is in the case of officers, the term retire is used where different age limits or perhaps tenures are indicated, and when a person completes that age or completes that tenure, his service comes to an end, and for this Army Rule 16A carries elaborate provisions with regard to retirement. There may also be compulsory retirement, which is prescribed under the Army Rules. The next term is release. So we have seen discharge, retire, and what is release? Release is also brings service to an end. Therefore, it is a separation from service liability. And there are three different contingencies in which release is invoked. These three contingencies are: firstly, when completion of terms of engagement. To illustrate, if there is a short service commissioned officer who is serving as a short service commissioned officer, and if his terms of engagement are 10 years, then when he completes 10 years service, he is released from service. He does not retire, he is not removed, he is not dismissed. His separation comes under the category of release, or before he reaches the terms of engagement, at his own request, when he is not entitled to pension, he can be released. And the release can also be in case there is a disease or infirmity under medical grounds, then that person can be released from service. That means he goes out from service and is separated from service. So therefore, these are three different contingencies in which the term release is used, and this is seen under Army Rule 15A and 16, the various provisions pertaining to release. Compulsory retirement, or the officers who are not found suitable or whom it is not desired that they should continue beyond a stage, then when they reach the age of compulsory retirement, well, they may be told that their services are no longer required and they are being compulsorily retired and their service comes to an end. So officers are liable to be compulsorily retired from service. Only an order from the central government is needed, and this is done when they reach the age limit specified for compulsory retirement, and in this regard Army Rule 16A carries the requisite authority. So you would have seen that under the conditions of service relating to separation, there are distinct and elaborate provisions under the Army Act and the rules which deal with the contingencies like retirement or removal, release, discharge, etc. from service. There are certain other contingencies that are explained to you with regard to officers. There is Army Rule 13A, where officer can be removed from service by the order of the central government on failure to qualify at an examination or course. Now, there are certain examination or courses which qualifying at which is necessary to continue in service, and if an officer has not qualified or he has failed to qualify or has not appeared at that examination or course deliberately, then he can be separated from service under Army Rule 13A. The second contingency is on account of misconduct by the central government. Now, the misconduct on the part of an officer is to be viewed at the level of the central government, and if the competent authority is of the view that misconduct is of such a nature and magnitude that it is not desirable that the person concerned is to be retained in service, then he can be separated under Army Rule 14. There can be grounds other than misconduct, for example, inefficiency or physical disability. Now, if a person is inefficient or he has become physically disabled, well, then it is not a misconduct, but then there is a lack in meeting the required standard on his part. And then Army Rule 15 has been framed to deal with these two contingencies, inefficiency or physical disability, and in which case the person can be asked to separate from the army. Then there is in military service is quite rigorous. It is in border areas, in inhospitable terrain where the climate may not be very conducive, and certain officers may uh, get afflicted by diseases, which makes their continuation undesirable. Then, on medical ground, a person can be removed or discharged from service, released. There is officer when he completes the minimum pensionable service, he may on his own accord want to go out, then it is retirement, and retirement at own request or resignation of commission. This term is used when a person is not entitled to retire, he gets no pension, for which there is Army Rule 16C. So Army Rule 15, 15A, 16A, B, and C are the provisions which are invoked, which are applicable in different specific contingencies, and these are as of routine when required, usually applied. Now, Army Rule 13 pertains to discharge of persons. I had said that discharge is a term which is not applied, which is not applicable in case of officers. Discharge is there only for persons below officer rank. That means GSOs, warrant officers, and then persons who have been enrolled and have been attested. We had seen in one of the earlier sessions what is attestation and those who have not been attested. So these four category of persons, for them, what are the contingencies for them to be moved out of the army service? Army Rule 13 is applicable in this contingency and lists out the applicable provisions and conditions. Now, I had mentioned a little earlier that military service is rigorous, it is in border areas, it is in inhospitable terrain, there are frequent exercises, and there may be engagements with the enemy, and any such contingency may bring about a change in the medical or physical condition of the officer, which renders him incapable of further service. And therefore, military service involves active duty performance, which is outdoor. It is usually in inhospitable terrain, and the service is of a hazardous nature. Adverse weather prevails for most of the time or during the year in such conditions. Say, for example, in Siachen Glacier, and these conditions entail danger to life and limb, and they are also fraught with stress and strain in that there is presence of the enemy forces close by, and there is separation from the family, and there can be psychological or mental pressures also. And these hazardous conditions may impact a disability. Now, disability is the deprivation of ability. It denotes the actual wound, injury, or disease, the disablement caused by which gives rise to a claim for compensation. Now, this disability, which is because of caused because of external factors or in service conditions, and a person is not as fit as he was before that disability came into being, and it is said that he has become disabled. The medical definition conveys that disability means unfitness, inability or incapacity of a body system to perform a particular type of function which the system is supposed to perform under normal conditions. Now, what is this system which I am saying? Body system. For example, it may be the visual capacity, means eye, or the hearing ability, the motor facility to walk, move around, the mental capacity. Any of these or more of these can be impacted, and the disability would be on account of such external factors. Now, the persons who have to go out, there are two very significant aspects, that what is attributability and what is the aggravation. Attributability means that what has caused that disability, injury, or disease. And in second case, it is not attributable. It may already be there, but it has become aggravated. It has become more severe. For example, a person had hypertension. He was continuing, and in a certain terrain, under certain conditions, which are aggravated, it becomes more severe. So it is said that it has aggravated. Now, both these factors can at certain situations justify award of a disability pension, means monetary benefit. So it's a casualty award, compensation for any disability caused during the performance of duties in service. But it should be related to service, and at least a causal connection must be established between the disability and military service. Now, supposing a person is in military service and he's sitting in a command post in an ops room where there is soundproof facilities are there, and suddenly he becomes hard of hearing. So there is no connection. If there is no connection between the service, why he should have become hard of hearing, then it is not attributable or aggravated by military service or service conditions. So it would be seen, is there even a causal connection between the military service and what has happened to that person? If there is a causal connection, then a person may become entitled to disability pension. On the other hand, if there is no connection, not even a remote connection, then disability pension does not become justified. An assessment of disability for all the persons in the armed forces is carried out by the medical officers or the doctors who are serving in the Army Medical Corps and who are the experts and specialists in different branches of medicine. And the law in this regard is contained in the pension regulations for the Army 1961, which have been issued by the central government, that is the Ministry of Defense. So these medical officers, the person concerned is required to report to the military hospital where he is seen and examined, and an opinion given by the medical officer whether he is entitled to any medical pension because of the attributability or the aggravation. Now, these two relevant aspects, they decide, and on them depends the award of disability pension based on a variety of factors. It depends on the constitution, the body build and the shape, the type of that person, his habits, the nature of the duties that were assigned to him while he was in service, and all these are taken into account by these experts and specialist doctors of the Army Medical Corps. Attributability means attribution to its principal source, and in this case, the principal source is the military service. Now, a large number of cases which come up before the Armed Forces Tribunal or even lead to the Constitutional Court, the Supreme Court of India, they pertain to disability issues where a person feels that he should have been given a disability benefit a pension, but he has not been given. So persons who are in military employment, they exercise their right to seek a remedy either from the Armed Forces Tribunal or the constitutional courts. Now, there are different types of monetary awards which come into play in the case of a death or disability, and these are death gratuity, as the name indicates. It is only given when a person who is subject to military and during the service, if he dies, then he may be entitled to death gratuity. On the other hand, if he becomes disabled or he becomes invalid, then if he is entitled to pension, he will get invalid pension. If he had not rendered full service to earn pension, then he gets invalid gratuity. Then, depending upon disability, say loss of hearing, loss of visual, or a hand cut down, or a leg broken, these are all disability. A person may get disability pension. Where a person is too severely disabled and he cannot carry out body functions on his own, requires a 24 hours somebody to attend to him, then may be given a constant attendance allowance. And if the disability is during hostile operations, then there are provisions relating to war injury. And the case law decided by the Armed Forces Tribunal or the constitutional courts, they serve as a guide to indicate as to what should be the approach of the authorities, medical authorities and military authorities when they are dealing with the matter of grant of disability pension. And therefore, it is the application of the pension regulations in case of individuals that is indicated based on the case law decided, which is available. And in this, the benefit of a reasonable doubt is always executed or is always considered in favor of the person who's going out, or means being boarded out from service. The person gets the benefit of doubt, and interpretation of the rules should be done in a beneficial manner, because these are welfare provisions, and therefore they should always be decided in favor of the claimant. These are some of the guiding principles that are borne in mind in the matters of deciding the award of disability pension. And therefore, it would have become clear and apparent that a thorough study of the legal provisions, together with the latest case law, it helps in rendition of proper legal advice, which is to be given by the military legal officers to the concerned branches of military service. Thank you.